two orders back to back by a Massachusetts federal judge, Brian Murphy, taking Donald Trump's words and throwing them back in Donald Trump's face. Blistering orders telling Donald Trump, don't you dare misrepresent what this court is doing, because your lawyers came in, represented your positions, then you are all whining about what you all said that you wanted. You want to see the transcript, Donald? Boom. Then you have federal Judge Murphy pulls out the transcript in these orders and then shoves it in Donald Trump's face. There's one case involving Donald Trump's Homeland Security deporting Burmese nationals to South Sudan. And then the Trump regime has the audacity to request a reconsideration of the judge's ruling after the judge agreed to what the Trump regime wanted, which was to conduct the immigration proceedings for these Burmese nationals in South Sudan at the airport where they were unlawfully taken in violation of the court's injunction. Judge Murphy's like, I did what you told me you wanted to do. So cut the crap and cut the whining and stop with this BS rhetoric that is going to get federal judges killed. Do you hear me, Donald? Then you have another case where Donald Trump unlawfully deported a gay Mexican individual to Mexico, had somebody fabricate a declaration saying that the individual who was deported to Mexico said he wanted to go back and didn't fear going back. And then right before a deposition was set to take place, under oath. That's why the Trump regime hates doing depositions. Voila. What happens? The Trump regime DOJ puts forward a declaration. They go, oopsies. It looks like the ICE officer who wrote the initial declaration made a mistake. They were just relying on hearsay, and there's actually nobody who will testify under oath that this homosexual Mexican person who was sent back to Mexico, who said he would get killed and sexually assaulted if he was sent back to where he fled from. You all said that he wasn't afraid. He was afraid, and y'all unlawfully deported him. And Judge Murphy said, just like Abrego Garcia, just like we saw in some of these other cases, facilitate his return right now, Trump regime. Let me take those declarations and words, and I'm going to throw it right back into your face, Trump regime. So I'm not just bloviating and just saying these things. May I do what I love to do on the MeidasTouch network, which is to actually go through the text of these orders with you so you can see for yourself what a good order actually looks like. So Judge Murphy issues this blistering opinion denying a motion for reconsideration by the Trump regime, where they just want to keep these Burmese nationals in South Sudan in perpetuity forever without due process and in violation of the court's injunction. Judge Murphy says, no, ain't happening. Here's what he says. Defendants have mischaracterized this court's order while at the same time manufacturing the very chaos they decry by racing to get 6 class members onto a plane to unstable South Sudan. Clearly in breach of the law and this court's order, defendants gave this court no choice but to find that they were in violation of the preliminary injunction. Even after finding that violation, however, the court stayed its hand and did not require defendants to bring the individuals back to the United States as requested by the plaintiffs. Instead, the court accepted defendants' own suggestion that they be allowed to keep the individuals out of the country and finish their process abroad. In the interest of full transparency, the court quotes at length from the hearing transcript. The court's taken out the transcript right now. So here's what went down at the hearing. This is what the court was saying to Trump's DOJ. The court. So plaintiff's counsel is suggesting that the only remedy is for the plane to return here so that these individuals be given an opportunity to raise any objections they have to being send to South Sudan. Do you, Trump DOJ, have another suggestion as to what a remedy that would allow these people to have the process that they are due might be? Trump DOJ, Mr. Ensign, if I may, we think any remedy should be narrowly tailored to the violation. And so, if Your Honor believes they weren't given a meaningful opportunity to express a fear under the Convention Against Torture, that the remedy should first be limited to giving them such meaningful opportunity. If they were to do so, then they would be given that reasonable fear interview. But bringing them back would be a much broader remedy than necessary because this court only requires compliance with procedures. And to the extent that Your Honor believes these procedures were not followed, the government should be allowed to provide those procedures, and that should satisfy the due process as it's being interpreted by the court. Thank you, Mr. Ensign. So let's say that I agree with you, that I want to make the most narrowly tailored order to address the violation of my preliminary injunction that is possible. What you're suggesting is that they can have a reasonable fear interview where they are now. Is that a practical possibility, Mr. Ensign? Your Honor, I don't know. I'd have to speak to my client, but I think that would need to be at least one of the compliance options that's presented, because that would be a much more narrowly tailored remedy that is actually tailored to the violation that Your Honor has found. After this exchange, defendants spent several hours conferring internally as to the feasibility of this option, ultimately deciding that it was doable. The court: I'm very much considering this, but if this is the route we go, my inclination would be to say, if you want to do all these interviews where they are in South Sudan, you have to do them appropriately. If you don't want to, you can always bring them home of your own volition and do it here. And so I'm not going to mandate that the department do anything overseas, but in an effort to craft as circumscribed a remedy as possible, I'm inclined to say if the department wants to figure that out, I'm inclined to let them. Mr. Ensign: and we appreciate that, Your Honor. And to the extent that it poses challenges that would be insurmountable, we would quickly inform the court and figure out. Use one of the options to comply with the court's orders. That's what Trump's DOJ said. Since that hearing, merely 5 days ago, defendants have changed their tune. It turns out that having immigration proceedings on another continent is harder and more logistically cumbersome than defendants anticipated. However, the court never said that defendants had to convert their foreign military base into an immigration facility. It only left that as an option, again, at defendants' request. The other option, of course, has always been to simply return to the status quo of roughly 1 week ago, or else choose any other location to complete the required process. So the court's saying, I've made this very, very simple for you. Now, Judge Murphy, so he goes, don't represent that I didn't allow you to do these things. You asked for it. I gave it to you. Now you're whining and you have Trump posting leftist radical scum, leftist radicals. This is what you asked for. Next up, Judge Murphy ordered that the Trump administration facilitate the return of OCG, an immigrant deported without a credible fear assessment to Mexico, where he had previously been raped and targeted for being gay. Here's what Judge Murphy says here. Plaintiff OCG has no known criminal history. After suffering multiple violent attacks, OCG sought protection in the United States, where an immigration judge granted him withholding of removal from his native country, Guatemala. This means that the immigration judge found it more likely than not OCG would suffer serious harm if sent back to Guatemala. 2 days later, and without any notice, OCG was placed on a bus and sent to Mexico, a country where he was previously held for ransom and raped. OCG had said during his immigration proceeding that he was afraid of being sent to Mexico and even presented evidence of the violence he had experienced there. But the immigration judge told OCG, consistent with this court's understanding of the law, that he could be removed to a country other than his native Guatemala, at least not with some additional steps in the process. Those necessary steps and OCG's pleas for help were ignored. As a result, OCG was given up to Mexico, which then sent him back to Guatemala, where he remains in hiding today. This is the second time plaintiffs have asked this court to order the return of OCG. The first time, the court declined to do so because the facts were in dispute. Defendants had submitted a declaration made under oath that OCG, prior to removal, affirmatively stated that he had no fear of being sent to Mexico. OCG adamantly contested this fact, submitting his own declaration stating that he was only told about Mexico essentially as it was happening, and that he begged to speak to his attorney but was denied. Because of this factual disagreement, the court declined to conclusively credit OCG's account and instead ordered discovery of additional evidence. Last week on May 16, 2025, defendants acknowledged a, quote, error in their previous filing and statements to the court. Defendants admitted hours before the scheduled deposition of the witness who could allegedly verify the facts included in the prior declaration made under oath that in fact there was no such witness and therefore no reliable basis for the statements put forward by defendants. Defendants apparently cannot find a witness to support their claim that OCG ever said that he was unafraid of being sent to Mexico. The only evidence before the court, therefore, is OCG's uncontroverted assertion that he was given no notice of his transfer to Mexico and no opportunity to explain why it would be dangerous to send him there. Defendants' retraction of their prior sworn statement makes inexorable the already strong conclusion that OCG is likely to succeed in showing that his removal lacked any semblance of due process, and it otherwise alleviates concerns about the appropriateness of the relief. Accordingly, plaintiff's motion for a preliminary injunction is granted. Facilitate the return of OCG. You see right there, Judge Murphy using the words of the Trump regime. This was your sworn declaration and using that against them. Powerful stuff. Tell me what you think. It's why I like reading these orders, so you can read for yourself what's actually happening right here and the constant lies by the Trump regime under oath and then to the public. Those were the transcripts. You've seen them for yourself now. Tell me what you think in the comments. Hit subscribe and let's get to 5 million subscribers. Thanks so much for watching, and thanks for supporting the MeidasTouch network. Share this network with as many people as you know today. That goes a long way to help our growth.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.